Under different statutes in India also, death penalty is awarded. For example, in the Army Act, the Air Force Act, the Commission of Sati Prevention Act, Narcotics, Drugs, Psychotropic Substances Act, SC/ST Prevention of Atrocities Act. We have death penalty in various forms in many of these statutes. Now, Section 53A, Indian Penal Code, talks about the fact that now transportation for life has been replaced with the term imprisonment for life. Now, imprisonment for life is a very important concept in the sense that for egregious crimes, we often find that instead of death penalty, we award imprisonment for life. What constitutes life? When we say imprisonment for life, it means for the entire period of life of the concerned human being. So, Section 55 of the Indian Penal Code talks about the power of the government to commute the sentence of life imprisonment. Can life imprisonment be commuted? In every case in which sentence of imprisonment for life shall have been passed, the appropriate government may, without the consent of the offender, commute the punishment for imprisonment of either description for a term not exceeding 14 years. This section curtails the power of the court to pass any direction saying that a prisoner should undergo imprisonment for a specific number of years. Now, Section 57 of the Indian Penal Code deals with the calculation of the fraction in terms of punishment, which says, as in calculating fractions of terms of punishment, imprisonment for life shall be reckoned as equivalent to an imprisonment for 20 years. Now, this is an assumption that we make. When we award punishment in fractions, we need to have a specific term attached to the idea of life imprisonment. So this is where the code has recommended that when we try to divide punishment into fractions, we treat life imprisonment to be of a span of 20 years. Section 53A of the Indian Penal Code states that instead of transportation for life, the punishment is now replaced to stand for imprisonment for life. This is an important provision of the Indian Penal Code whereby transportation has been done away with as a modality of punishment. Now, Section 55 of the Indian Penal Code states that the government has the power to commute the sentence of life imprisonment, and in doing so, once the government commutes the period of life imprisonment, it shall not commute this punishment for imprisonment of either description for a term which that doesn't exceed the period of 14 years. Now, other than that, it is also important to mention that Section 57 talks about the calculation of fraction of terms of punishment. Now, when you say life imprisonment, the period ideally is an indefinite period, because you never really know for how long the person is going to survive, and life for one person the duration may differ from one person to another person. So this is where we need to find out a method or mechanism by which we can restrict the phase of punishment for a fraction, for which it is necessary to understand that according to the code, when we try to make fractions for life imprisonment, we also simultaneously take life imprisonment to be for a period of 20 years, because that's how the fractions can be easily made. Apart from that, the code provides that imprisonment shall be for either description, which means that it could be either simple or rigorous. What is meant by rigorous imprisonment is an important question. Rigorous imprisonment is a form of imprisonment where the convict is asked to spend his time behind bars or is incarcerated, and at the same time he has to undergo manual labor. On the other hand, in simple imprisonment, manual labor is not a necessary feature. Now, the other form of punishment which has been prescribed in the Indian Penal Code, as we discussed in a while ago, is under Section 61, which talks about forfeiture of property. Now, forfeiture of property is not a very common modality of punishment which is available under the IPC. However, it still exists in the code, and therefore it's necessary for us to understand what is meant by forfeiture of property. Section 61, which specified sentence of forfeiture of property, has been repealed by the Indian Penal Code Amendment Act of 1921. So right now, the provision has been repealed by the Act of 1921. At present, there are two sections in the IPC, namely Section 126 and 127, that talk about forfeiture of property. Section 126 of the Indian Penal Code, committing depredation on territories of power at peace with the government of India. Now, this is one section under which forfeiture of property exists in one form or another. So it says, whoever commits depredation or makes preparations to commit depredation on the territories of any power in alliance or at peace with the government of India shall be punished with imprisonment of either description for a term that may extend to 7 years, and shall also be liable to fine and to forfeiture of any property used or intended to be used in committing such depredation or acquired by such depredation. Likewise, under Section 127 of the Indian Penal Code, receiving property taken by war or depredation mentioned in Sections 125 and 126, forfeiture of property has been awarded as a method of punishment. Now, the final form of punishment which has been awarded in the Indian Penal Code is fine. The IPC provides that fine is a prescription of a modality of punishment. It is a form of penalty which can be given to individuals. It can be both independent or it can be given with or in addition to other penalties. Different offences attract different amount of fine. Section 63 lays down that where no express amount of fine has been mentioned, there the fine may be unlimited, however, it should not be excessive. Section 64 says that there is a sentence for non-payment of fine. So if an individual has to pay a fine but fails to do so, he shall have to compensate for it by undergoing some sentence in exchange or in lieu of the fine. IPC has various penalties which are actually used differently in each specific offence. The nature and term depend on the offence, so does the amount of the fine to be penalized. It is all the discretion of the court in several cases. IPC is an amalgam of various forms of punishments, as we have seen, but one has to note the reason for having fine as a prescription of punishment. Normally, monetary damages are awarded in civil cases. So what is the rationale behind having monetary compensation in criminal offences? Because the idea is to enable courts to help the victim in one way or another to restitute their life or to bring back some form of normalcy. So sometimes courts use the fine amount for awarding a compensation to the victim as just a monetary relief. One has to remember at all circumstances that fines do not in any way have the same status as damages, because in civil law the understanding is that once there has been an injury, it is possible to compensate the person because of the civil wrong. You can compensate the person financially or by using money. However, in criminal offences, once the offence has been committed, the damage is considered to be irreparable. So fines are just a modality of allowing some monetary relief to the victim. Courts often use this amount to award monetary relief to victims. Other than that, it is not seen as a measure of compensating the victim in toto. So this was a discussion and a detailed discussion on various forms of punishments which have been provided in the IPC. Before you look to other modules, let me tell you that punishments under the Indian Penal Code form a very important content. Now, when we discuss punishments, the death penalty is one of the most controversial areas in relation to punishments under the IPC. That would be all. Thank you.